Good morning, this is your Kelso Report for Tuesday, April 10th, and I'm your host, Clark Kelso. Well, we had a number of interesting cases yesterday. An intellectual property case involving copyright infringement, a First Amendment Bivens claim, a case arising under the Religious Freedom Restoration Act, and then in the California Court of Appeals, labor law, property law, and criminal sentencing, a fairly interesting range of cases. We'll begin with the Ninth Circuit and its copyright decision, a copyright infringement case. Yes, the District Court in LA Printex Industries versus Aeropostale had granted summary judgment to the defendant in a copyright infringement case involving alleged copying of fabric designs. The summary judgment was based on the court's conclusion that there was no question of fact regarding either the defendant's access to the plaintiff's designs or the issue of substantial similarity. Now, the Copyright Act protects owners from copying by infringers, but absent direct evidence of copying, which is rare, and there was none in this case, the courts permit a plaintiff to show copying by proving access and substantial similarity. Well, the Ninth Circuit reversed the District Court's decision in this case, finding fact questions on both access and substantial similarity. As for access, the plaintiff had sold more than 50,000 yards of fabric containing the copyrighted design, mostly within the Los Angeles area, over a 5-year period. And the defendant, an apparel manufacturer and vendor, was located in Los Angeles. The Ninth Circuit concluded that a reasonable jury could find that the copyrighted pattern was widely disseminated in the Los Angeles area fabric industry, and hence that there was a reasonable possibility that defendants had an opportunity to view and copy the design. As for substantial similarity, the District Court had emphasized differences in its opinion, while the Ninth Circuit focused on the similarities. In particular, the Ninth Circuit decided that the design elements within the overall floral pattern of the fabric were substantially similar, particularly since, as noted in a prior Ninth Circuit opinion, there are, quote, gazillions, close quote, of ways in which a floral pattern might be designed. A bit of exaggeration, perhaps, but that's what the Ninth Circuit opinion said. Well, in this case, there was similarity in the small size of the flower bouquets, with a similar shape and number of flower petals and leaves, similar small 3-leaf branches interspersed between the two bouquets, and the bouquet and branches are coordinated in similar spatial combinations, on a grid of similar scale and layout, with similar use and arrangement of similar colors. Well, there was enough, in other words, to create a fact question for the jury, and the case now goes back to the District Court for further proceedings. Sounds to me like the defendant should be settling this one pretty quickly. Next, we have a First Amendment Bivens case, of all things, involving the Secret Service. During the 2004 presidential campaign, the plaintiffs, along with others who opposed President Bush, organized a demonstration at a campaign stop in Jacksonville, Oregon. The plaintiff's complaint alleges a Bivens-style claim against several agents of the Secret Service who allegedly implemented a viewpoint discrimination policy of making sure that protesters were kept further away from the president than supporters. I can't help laughing at this. The first complaint was dismissed by the Ninth Circuit in earlier proceedings because the factual allegations in support of the allegation of viewpoint discrimination were too conclusory to overcome the agent's qualified immunity. Well, the amended complaint now apparently passes muster, according to the Ninth Circuit, in Moss v. United States Secret Service, where the court held the complaint was specific enough in its allegations to survive a motion to dismiss. In essence, the amended complaint established that the protesters were kept at least 1 block more away from the president than supporters, while the president was dining at a restaurant, and that along the presidential limousine route, supporters were permitted to line the route while protesters were kept a block away. The Ninth Circuit accepted the argument that the additional distance constituted a substantial burden on First Amendment rights because the protesters, because of their increased distance, were less able than supporters to communicate effectively with the President. The court emphasized that its holding was premised just upon the allegations in the complaint, and that the agent's qualified immunity may yet block a damage judgment, since the agents may be able to show that their actions were motivated not by viewpoint discrimination, but by a desire to protect the President. Now, I think we'll also see whether the Supreme Court uses this case as an opportunity to decide whether a Bivens damage claim really exists for a First Amendment violation, an issue the court has reserved as recently as 2009. Fascinating case. Next, we have a case arising under the Religious Freedom Restoration Act. The scope of relief available under that act was before the Ninth Circuit in Oklahoma Native American versus Holder, which involved a claim for injunctive relief to bar the government from enforcing the Controlled Substances Act against the tribe's religious use of marijuana, and a claim for damages for the government's prior seizure of large amounts of marijuana from the tribe. The district court dismissed the claim for damages, holding that the Religious Freedom Restoration Act simply does not authorize a claim for damages. The Act does not expressly authorize a damages remedy, and the plaintiffs were seeking damages under statutory language, providing only for, quote, appropriate relief, close quote. However, that language is not a sufficiently clear and unambiguous waiver of sovereign immunity to make damages available, so the Ninth Circuit affirmed the dismissal of the damages claim. Now, the district court also dismissed the claim for injunctive relief, holding that the prospective claim was not yet ripe. The Ninth Circuit reversed this dismissal, however, concluding that the complaint alleged a sufficiently concrete intention for continued use of marijuana in religious ceremonies, and for the likelihood of continued prosecution, to satisfy Article 3 and prudential standing requirements. Next, we turn to the California Court of Appeal, and we begin with a labor law case in Williams versus the Public Employment Relations Board. The plaintiffs were members of the Faculty Bargaining Unit at CSU Northridge. Now, they had, however, refused to join the union, so they paid reduced fees to the union as a condition of employment. When the university proposed that professors take 2 furlough days a month, the union gave all union members the opportunity to vote on the proposal. Non-union members, but who nevertheless were paying the union for their representation, were not allowed to vote, but they were allowed to make their views known by submitting comments to the union. Well, these 2 professors sued the union, claiming that their federal and state constitutional rights were violated by denying them the right to vote, and that the Public Employment Relations Board unlawfully failed to issue an unfair labor practice complaint. The Second District rejected all of this nonsense. Needless to say, there's nothing in the federal or state constitutions that entitles a union or a non-union member to cast a vote in a union-run internal election. The constitutions just don't speak to that issue. The court also held that there was no statutory violation, since the question of who to permit to vote in these circumstances was an internal union issue. Next, we had an interesting property law case involving a homeowner association's organic law. The organic charters for many older homeowner associations had required supermajority votes for amendments. Unfortunately, as is true with most voting, voter apathy and other reasons often make achieving a supermajority just impossible. So Section 1356 of the Civil Code creates a court procedure for lowering the supermajority requirement. The plaintiff, in this case, Quail Lakes Owners Association, filed a petition seeking an order modifying its governing laws to reduce the supermajority voting restriction, and the trial court conducted a hearing and granted the petition. A sole objector, one Vladimir Kozina, timely filed his objections and an appeal. In Quail Lake Owners Association versus Kozina, the Third District rejected the appellant's contentions that the manner of notice denied due process, and that the trial court abused its discretion in granting the petition. The due process claim was based on the facts that the court had on August 5th ordered a hearing date of September 2nd with notice to be given to the homeowners on or before August 13, with any written opposition to the petition filed only 4 days later on August 17, and there was an intervening weekend. Well, nevertheless, on August 16, Cozina filed his objection, asserting that the short time for preparing an opposition denied due process. Unfortunately, in his haste, he nowhere in his brief contended that he was unable to articulate all of the arguments he wanted to make, or unable to muster the evidence he wanted the trial court to consider due to the time constraints. So he didn't show that there was any prejudice. Absent that showing, the 3rd District rejected his due process argument. On the merits, the court found that the trial court had considered and made appropriate findings on all 6 of the required elements for granting a petition under Section 1356. Cozina, he focused his fire on the court's initial oral ruling in the courtroom, which frankly was incomplete. But that ruling had only directed counsel to prepare a final order. And it was the final order that constituted the court's decision and from which the appeal was taken. And the final order was complete and had all the requisite findings. So the 3rd District affirmed. Finally, criminal sentencing. In People v. Wade, the jury found defendant guilty of grand theft for stealing a purse which contained $700 in cash. At the time of the verdict, the trigger for grand theft was theft of property worth more than $400. Well, after the defendant had taken his appeal in 2010 as part of Governor Brown's realignment legislation, the trigger was raised to $950. That's a little bit more grand than $400. And because the defendant's conviction was still not final, the 1st District held that the 2010 amendment applied retroactively, since the legislature was motivated by a desire to save money by avoiding sentencing certain defendants to prison as opposed to local county jails. And there was no contrary expression of intent in the amendment or its legislative history. Well, that was it for a Monday, and that's it for today's Kelso Report. Have a great day in the law.